Hey everyone, welcome back. Today we're taking a look at 4 sovereign citizens across 4 different courtrooms. And let's just say none of them are making the smartest choices. Our first stop is Judge Washington's courtroom, where a tenant is being evicted. But instead of cooperating, someone with the exact same name, birth date, and address is flat out refusing to leave. Let's dive right in.
All right, the court will call the case of the Ranches of Rosebrook versus A Nice Battle, case number 25C-1245.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Ms. Battle, please hit star 6, unmute your device and state.
Hello? Hello?
Please state.
It's a niece battle on a special appearance for the record to contest the jurisdiction and the facts before this court.
Yep. All right. Well, Ms. Battle, I'll tell you that this matter is appropriately in the correct court. The court does have jurisdiction.
And that's based on what? What is on the record that is based on that the court has jurisdiction?
The fact that this is a case that is within the jurisdiction of the Township of Ypsilanti, and if you have issues related to any contracts, that would be within this jurisdiction as well. So all of that is within the jurisdiction of this court.
So you're saying that the contract is in jurisdiction of the court?
That is what I just said, ma'am.
All right, and the contract has been rescinded. So how is the contract in the jurisdiction of the court if it's invalid?
Who gets to rescind a contract on their own? That's
what are you talking about? I have the right to rescind a contract by right of common law.
Ms. Battle,
that doesn't involve court.
Ma'am, you need to stop talking or you're going to get held in contempt of court. Mr. Fantier, have you had a chance to talk to Ms. Battle? Talk to Ms.
You're breaking up. I can't hear you.
Mr. Fantera, do you need to speak with her, or are we ready to...
If you want me to speak to her, I'll speak to her. She talks about rescinding the contract. Does that mean she's moving out?
She claims she's rescinding the contract because she's the estate holder of her so-called strawman, and insists she's protected by the UCCC, the USC, and even the Treaty of Peace and Friendship. If any of that actually makes sense to you, then chances are you've watched far too many of these cases, just like I have.
I'm sorry, you're breaking up.
Are you moving out?
Are you moving out?
No. Why would I have to move out?
Because if you rescind a contract, okay, fine. Your Honor, I think let's set this for trial.
Okay. One moment.
This case has also been it's in the circuit court. A petition filed for an injunction. I did serve you all. It is set on the 30th.
Yes, ma'am. I heard.
We're aware.
Okay. And once again, I do not submit to the jurisdiction of the court. The contract is rescinded.
So how can the contract...
And I am not a legal person.
You're not a legal person?
How can a contract... No, I'm not a legal person. I'm not a legal entity. No, I am not. And you have to prove that on the record.
Actually, I don't.
I'm sorry?
Can I ask Ms. Battle a question, Your Honor, real quick?
Sure.
So, Ms. Battle, so you can live there forever without paying rent because you're not a legal person?
That's not what I'm saying, but the contract itself is invalid. I'm saying that you don't have any personal or subject matter jurisdiction over me. Over an invalid contract, no. And over me not having a legal capacity to be sued, yes. So if that's how you want to take it, then that's how you have to take it. But that's what's lawful, and that's what's written in the law.
Let me just tell you, I think you're wrong on both counts. I would expect that we would...
It's okay for you to think that I'm wrong, but the facts still align with what I'm saying.
Okay. Your Honor, I think we should have a trial.
You have to prove without the reasonable doubt. So let the record show that the judge has not required the plaintiff to prove without a reasonable doubt that I am a legal person, and it's on the record, not assumed, not presumed, on the record. There's nothing that's on the record that states...
Ms. Battle, first of all, reasonable doubt is a standard in a criminal case, not a civil case. So I do not have to prove anything beyond a reasonable doubt.
Sarah, I need both of you to stop talking, please. Both of you, I'm sorry. I cannot figure out the date because I can't hear over the two of you.
I apologize. I didn't know that's what you were doing, Your Honor.
This matter will be scheduled for May 6th at 3 p.m. for a trial on any and all issues that may be before the court. Ms. Battle, if you have anything else that you need to say, you can unmute yourself by hitting *6 to do that.
Okay, I just find it ironic that I got muted when I was speaking on jurisdiction and how there was a lack thereof on the record. So I want that to be on the record. But I also wanted to, okay, that's fine. And I also wanted to be on the record that I am not going to be able to show up on May the 6th. So it's also ironic that you are able to verify with him that he's able to show up and not with myself.
I just asked you that, and you are now talking about something else. Why can't you do this?
That's because you cut me off and put me inside of a break room and muted my mic instead of allowing me to speak on what needs to be spoken on.
All right, this is set for May 6th at 3.
Your Honor, by Zoom? By Zoom?
Correct.
All right. Thank you, Your Honor.
It's ridiculous. This is a fraud upon the court. Goodbye.
This is outright fraud. One of the classic sovereign citizen tricks is signing a lease with no intention of ever paying rent. They move in, refuse to pay, and then drag out the eviction process in court for months. It might buy them some time, but it only works temporarily. Now, let's move on to the next so-called brilliant case.
All right, this is in the matter of the people of the state of Michigan versus Shane Leroy Reamer, file number 23-216665FH. This is the date and time set for a final pretrial conference. Today was the motion deadline for both motions and motion in limines to be heard. Jury instructions were to be provided to the court by April 2nd, along with any proposed voir dire questions. We are set for trial on April 22nd of 2025. Mr. Reamer, you are charged with police officer resisting and obstructing causing injury, which carries a maximum penalty of up to 4 years in prison. Police officer assaulting, resisting, and obstructing, that carries up to 2 years in prison. There's 2 of those. And then there's a disorderly. And what is the plea offer in this file?
Your Honor, the people have offered to a plea of 2 counts to attempted R&O.
All right.
So 2 misdemeanors, and we would kill a brute to no upfront jail.
All right. Mr. Reamer, the plea offer in this case was to plead to 2 one-year misdemeanors with no upfront jail, and there'd be like 12 months or so of probation, some minimal fines and costs. Do you understand that? All right. Now, Mr. Reamer, you know, I'm assuming you graduated from high school, right?
8th grade.
You went through 8th grade, and this is a felony that could result in you going to prison. Why don't you stand in front of that podium for me? So do you understand an attorney can help guide you through the legal process?
Yes, I tried to have, I almost had a public defender. Unfortunately, she wasn't representing me appropriately. I had asked for another one, but.
So I have no authority over who gets appointed. You're appointed an attorney.
I understand that, but when they're not representing you appropriately.
Okay, I didn't ask that. I'm just saying you have a right to an attorney. I know the attorney you're referring to. She's diligent. She works hard. Maybe you didn't like, I know when I was a public defender, sometimes my clients didn't like what listen to me, I'm talking. My clients didn't like the things that I told them. But, you know, her job isn't to do what you want. Her job is to represent the law. So you understand at this point, you can hire an attorney, or you can go with the public defender and whoever they assign you, or you can go to trial pro per with no law degree, no experience, and risk going to prison. You're going to represent yourself.
I'm going to represent I ain't got no choice but to represent.
Yes, you do have a choice. The judge just offered you a lawyer, someone with more education than an 8th grade diploma. And considering that jail time is a very real possibility here, you'd probably be wise to accept the help.
Your jury question, the voir dire questions, because if you haven't, they're waived.
If there's
No, they were due.
If there's evidence provided against me, I have a right to defend myself using that very same evidence.
That wasn't the question I asked you.
You
do have a right to defend yourself, Mr. Reamer. I'm just
my right for violence.
I'm talking, you're not. If you don't stop talking and listen to me so I can go through my speech, I will send you over to the jail. Do you understand? All right. you have not filed any motions. Jury instructions were due and voir dire questions were due. You have not provided those. We gave you a copy of this. So do you understand what I've received is what will be used? Yes or no?
I will be allowed to ask my questions.
What question?
When I'm cross-examining, I will get my.
I'm talking about juror question. I'm talking about jury instructions and voir dire questions. You understand now? You didn't file, listen, I know, but you waived that because you have not provided them. Do you understand that? Do you understand that?
No, I don't. I don't
Okay.
understand that. I didn't understand that.
Okay, well, I
That's why
can't advise you of the law because I'm not an attorney, I'm a judge.
No, but
So-
you're looking at the case and you've been presiding over my case for 3 years now.
I know, it's fine. You're
the
gonna
one-
go to
You're the one
trial.
that signed the warrant for my arrest while I was in jail.
I don't know that, I don't
Yes,
remember.
you did do that.
Okay, I'm allowed to do that.
No, you violated my rights as well.
Okay, well, you have options. You can file a complaint with the JTC if you'd like. So are you prepared to go to trial?
Absolutely.
Have you provided your witness list?
I haven't yet, but I will.
Okay, that was due.
My witness list was provided when, Ms. Underwood was my attorney.
Okay,
And my witness list is.
have you subpoenaed any witnesses that were not on the prosecutor's raised just eyewitness list?
Yes, my witnesses are the ones that was there at the scene.
No.
And
Do
yes,
you understand that you have to provide a witness list and you have to provide a copy to the prosecutor? Do you understand that?
prosecutor, I gotta provide what to him?
So if you're gonna have witnesses at trial, you need to make sure the prosecutor has their name and contact information so that they could interview them prior to trial if they wanted. Do you understand
Well,
that?
they got all that information.
They do?
Yes.
Okay,
Yes.
so,
My witnesses are my parents and my aunt.
Your witnesses are your parents and your aunt? And what exactly are they supposed to testify to? That your mom once used your baby head as a bowling ball? Honestly, that would at least explain the kind of thought process we're seeing here.
okay, I don't know, are those on, if they're not on the people's witness?
Curtis,
I'm not
Benny,
sure.
Okay,
Rose.
if you haven't provided a witness list and they're not on the people's list, you understand you won't be able to call them.
Okay, I will provide the information. I
Okay.
can provide that information. Yeah.
I'm just telling you. So you need to make sure that there's a witness list in the file that was provided to the people.
So I gotta re-provide it.
I don't know. Go back and look at what
I'll
witness
just-
list
I'll
has
just
been
do that
filed,
next week.
their name, their contact information, and then any subpoenas you have to do. If you have to subpoena anybody to be present, you need to get those filed this week. And then the court signs them and then you serve those people with those.
Okay.
Do you understand? Now, do you understand when we go to trial, a lot of times some of the questions you ask or he asks may be objected to, and it's not personal, it's just, we have to follow the law.
Yeah.
Okay,
I'm allowed to object to though, right?
huh?
I'm allowed to object to.
You are, and then you have to provide the basis for that objection. Okay, so you need to understand your objections. So you might want to do some research to understand.
I've been doing.
Good, good. You sure you don't want a public defender for trial?
Huh?
You sure you don't want an attorney for trial?
I'm not gonna take any.
Sovereign citizens tend to believe that all lawyers are corrupt, just like flat earthers and anti-vaxxers insist science is fake. At the end of the day, it's simply easier for them to cling to conspiracies and admit they don't actually understand how the system works. He's got another hearing coming up, and we've still got 2 more cases to cover.
I am Brian. My family name is Wilkinson.
All right. We'll go on the record in State of Kansas versus Brian J. Wilkinson. Case number 25 CR 67. The state appears by County Attorney Darren DeVinny. Mr. Wilkinson appears in person by Zoom. We're here for a first appearance. Mr. Wilkinson, you're appearing by a summons. I'm going to go over your charges with you. There are 3 counts, all alleged to have occurred on June 4th, 2024 in Butler County, Kansas. Count 1 alleges you were in unlawful possession of methamphetamine. That is a level 5 drug felony. Count 2 alleges you are in unlawful possession of paraphernalia for use. That is a Class B non-person misdemeanor. Count 3 is an allegation of possession of marijuana, also a Class B non-person misdemeanor. Do you understand what you've been charged with, Mr. Wilkinson?
I do not understand, Your Honor.
Okay, what don't you understand?
I had thought that this matter was already settled on the case that Mr. Watts was representing me for.
Okay, I'm not aware of that particular matter. That may have been a different case. I'm not sure.
Well, there wasn't a different case. I mean, I wasn't attacked and assaulted and kidnapped 2 different times, just one time.
Are you really sure about that? Because most sovereign citizens can barely count from 1 to 2, especially after they've taken a few too many trips down Crystal Lane.
Mr.
And
Devaney, do you know
I've
anything about another case involving Mr. Wilkinson?
Let's see. Well, I know there's criminal history. I know he's a B on the grid. He has out of at least Butler County cases, we've got a driving while suspended, an old 23 traffic case that's closed. And then he has this open case now for possession of methamphetamine.
Do you know of, is there one where Mr. Watts representing that you know of?
Not that I'm aware of. Well, Your Honor.
All right. Well, I don't know, Mr. Wilkinson. That can be sorted out. Can you afford to hire an attorney to represent you?
I'm sui juris.
Excuse me?
I'm sui juris, and I would appreciate it, Your Honor, if you would recite your oath of office, your delegation of authority order, and your bond information.
I'm not going to do that, Mr. Wilkinson. Can you afford to hire an attorney?
I am not a ward of the court. I'm not an idiot. I know how to speak for myself.
Okay. Do you wish to represent yourself?
Well, I am myself. I can't represent myself, but yes, I will be talking for myself.
All right. You understand you have a right to have an attorney represent you on this case?
Yeah, but that makes me a ward of the court if I am seen as too stupid to talk for myself.
Do you understand that if you can't afford an attorney to represent you, one would be appointed for you?
I also understand that all attorneys' first duty is for the court and not for their client.
Public defenders are there to protect your actual rights, not to guide you through some legal fantasy land. Yes, they work for you, but they also swear an oath to the court to be honest and to file legitimate motions. So if one refuses to submit your ramblings about flags and birth certificates, it's not because they're against you. It's because they're not about to risk their law license over your delusions.
Do you understand you have that right, Mr. Wilkinson?
I do understand my rights, yes.
Okay.
Your Honor.
I'm going to go ahead and appoint James Watts to represent you if you think that he's represented you on something that may be in line with this case. So he'll be with you when you appear back in front of me, and that'll be on my preliminary hearing control docket. Do you have something to write with, Mr.
Yes,
Wilkinson?
sir.
All right. Your court date will be in front of me by Zoom on May the 19th at 2:30.
May 19th, 2:30 p.m.
That's correct. Do you have Mr. Watts' contact information?
Yes, I do, Your Honor.
Okay. You might contact his office and let them know that court date. We need to set a bond. Mr. Devaney, what's your recommendation for bond?
The defendant does appear here voluntarily by summons here today, so I'd request a $10,000 OR bond for the defendant.
What was the amount?
$10,000.
All right. I'll set a $10,000 OR bond. He'll need to be processed, I'm assuming.
Well, he initially had a first appearance back on June 5th of 24 at 1:30. At that point, we were waiting on KBI Labs and we released him. So I believe he's actually been arrested and processed.
Okay.
He just needs to come to 201 West Pine. If he can make it here today before 5, that's great. If not, probably on Monday to come up to the front desk so he can sign his bond.
All right, Mr. Wilkinson, can you make it up to the Judicial Center this afternoon to sign your OR bond?
It'll probably need to be Monday, Your Honor.
It's always hilarious when sovereign citizens insist the court has no power over them, but then turn around and sign a contract for a PR bond, which actually gives the court even more control. And with that, we're on to our final case. This one takes us to Texas.
Good morning, Your Honor. My Christian name is Jose and my family name is Elizondo. I am the bailior today and respectfully ask some issues to raise.
Wait, Mr. Elizondo, wait. Jose Elizondo, I show that you have one case pending and that is expired registration. Do you understand that's the charge that is pending against you?
Yes, I understand, but
Okay,
respectfully.
sir. Okay, hang on. There's several steps we need to take over. Were you able to hear my explanation about defendant's rights and
Yes.
options that I went over at the start of court?
Yes,
Do you have any questions about those rights or options?
yes.
Go ahead. What's your question?
Okay, respectfully, I haven't received my documentation that I requested in a timely manner to proceed today.
No. What is your question?
Outlined
No,
in
no,
the court
no, Mr.
form.
Elizondo, no. What is your question about the rights and options that I went over at the start of court?
I have no questions regarding that.
Okay, then to this charge of expired registration, actually, I'm going to stop and say, you mailed in payment.
I did.
You mailed in $3 and you have a balance due of $129. So with that payment of $3, we've already entered a plea of no contest for you because Texas law allows that to be entered for you. So we're set here to determine, are you able to make the balance of your payment by Monday, or do you need some time to pay that out?
Your Honor, respectfully, as a bailior and grantor, I've granted this court equitable title for settlement of any.
No, sir,
charges
this is a
under
criminal court. No, sir,
trust merge.
Mr. Elizondo, this is not a civil court. There are no parties like that in this proceeding. You're a defendant, you're not a grantor. I'm the judge. And so that does not apply to this court. You may have read that might be something in a civil court. That does not apply here. So my question to you, sir, is since you've already mailed in payment and indicated a plea of no contest by mailing in a payment under Texas law, can you get the balance paid by Monday? Or do you need some time to pay that out? Or do you have a financial situation that you need a financial packet?
Your Honor, for the record, respectfully, I am a Texas common law free man. I do not participate in corporate Ponzi schemes that require me to have
This
registration.
is not that, sir.
and
This is not,
insurance.
Mr.
I do
Elizondo,
not
stop.
consent.
Mr. Elizondo, stop. This is not the time to make a statement. You see, we have like 12 other people who are set here. You're set on a criminal charge. This is not time for you just to go and make a statement about a civil matter that it is not set in this court.
So are you saying that I don't have civilian due process of law?
No, but this is not a civil matter. You're raising terms in regards to this as if this were like a civil lawsuit. This is a criminal charge where
It's
you've
not
already.
criminal, Your Honor.
Yes, it is, sir. This is a Class C criminal charge in Texas, displaying an expired registration. That is a Class C criminal charge, and you mailed in partial payment. So I'm trying to determine, are you able to make the rest of your payment by Monday, or do you need some time to pay it out?
I have the right to equitable title for this settlement or any charges on the doctrine of trust merge.
This is
And
not a matter. This is not a
respectfully,
matter of a
Your Honor.
title to a vehicle or anything like that, sir. You seem to be confusing some civil law.
Well,
with the
I
pending
have
criminal.
some confusion because on Supreme Court case law Murdoch versus Pennsylvania, they clearly state that you don't need registration or insurance for private personal travel, and I don't consent to any.
You brought up Murdoch versus Pennsylvania, as if it somehow proves you don't need insurance or vehicle registration. The problem is, that case was about religious freedom, not the right to travel. So no, it doesn't apply here.
Well, this is nothing to do with a corporation. This is a Texas charge, and you've already mailed in a payment for this. So you've indicated a plea of no contest. Are you saying that you're not pleading that? Then why did
Your
you
Honor,
mail in
as a
$3?
bailior and grantor, I gave
No,
this
let me,
court
no, Mr.
equitable title for
Elizondo,
settlement
stop. Mr.
of
Elizondo,
any
stop.
charge under
Mr. Elizondo.
doctrine of trust merge.
Mr. Elizondo, stop. Why did you mail in $3?
Because as a bailior and grantor, I have granted to this court equitable title for settlement of any.
No, sir, we do not settle.
charges
And, sir,
under trust
Mr.
merge.
Elizondo, there's no party in a criminal charge that's called a bailior, and you cannot claim a position that is not one in this court.
Your Honor.
There's
are
no
you giving
status
me-
of bailior.
Are you giving me
No, sir, listen, I need you to listen to me. I need you to listen to me. There's no status of bailor or grantor in this criminal court. You may have read some cases in regards to some other matter. You are a defendant. No, Mr. Elizondo, you need to be quiet and listen. You're a defendant. You mailed in $3, which is partial payment of a total of $132. All right. Now, by law, when you mail in a payment, a plea of no contest is entered. All right. So my question to you was, when you mailed in the $3, was that your intent to make a partial payment, requesting a payment plan, or were you attempting to post a bond?
My intent was, like I said, I am the bailor and grantee. I have granted this court equitable title for settlement of any charges under doctrine of trust merge. That's my answer to your question.
Okay. That is not an answer that applies in criminal court. So based upon your payment of $3, the court has already entered a plea of no contest, and I'm going to order that you get the balance paid
Your Honor,
within
respectfully.
30 days.
Okay, Your Honor, respectfully, with those documents that you have, I didn't receive any documentation requested in a timely manner to proceed today. Outlining my full
Sir,
until
if
under
you-
Chapter 66 of Texas Civil Practice Code, which
Okay,
is
stop.
provable
Mr. Elizondo,
and
Mr. Elizondo, stop. The Civil Practice Code does not apply to this courtroom. This is the Code of Criminal Procedure applies to the criminal courtroom. So the Civil Code does not
But
apply.
I still have a civilian due process, Your Honor.
Well,
And I
yes,
have not
but
entered a plea.
you did by mailing it in. By mailing that in, that's entering a plea of no contest. You mailed in a payment of $3.
Your Honor.
You can
Like I
get the
said,
balance paid.
The reason why I did that as a bailor and grantor, like I stated multiple times, I've granted this court equitable title for settlement.
Okay,
under
Mr.
any
Elizondo.
document plus merge.
Mr. Elizondo, were you wanting to plead not guilty and request a trial?
No. Respectfully, Your Honor. Constitutionally, too. For the record, I am a Texas common law free man. I do not participate in any Ponzi schemes that require me to have registration and insurance. I do not consent quasi-jurisdiction. Respectfully, Your Honor, I plead for a civilian due process of law.
Okay, well, you're
Under
receiving.
Section 1, Article 10.
Okay, Mr. Elizondo, you're receiving the exact same due process that every other person who's appeared in this court has. And you have mailed in a payment of $3, and that payment is received as a plea of no contest.
Who is my accuser, Your Honor? Respectfully.
The state of Texas. That citation that you received, that is the accusation. And
Okay, well, I would like to go to trial for this.
so you're indicating that you wish to change your plea from no contest to not guilty?
Yes.
All right. And you wish to waive your right to jury trial, or do you wish to request a jury trial?
No.
So no jury trial. You wish to waive your right to a jury trial?
1 second, please. Never mind. Give me a jury trial, please.
So you wish to request a jury trial?
Yes.
And you will be representing yourself, or will you be retaining counsel?
Myself.
That wraps it up for today. Every one of these folks still has more hearings ahead, so stay tuned for the next round of courtroom chaos. If you enjoyed the video, hit like. If not, feel free to hit dislike. Either way, drop a comment and make sure you're subscribed with notifications turned on so you don't miss what's coming next. I'm Team Skeptic, and I'm out.